So my name is Alex Ward, and I am a criminal defense attorney here with Gross McGinley. And I'm here today to talk to you a little bit about bail. Now, what is bail? Bail is the conditions that will apply to your criminal case before your case is resolved at trial, either through plea or through the trial process. And the first thing that you need to know is that there's 4 different kinds of bail. The first kind is called ROR, recognize on your own recognizance. And essentially what that is that you are released on bail with a promise that you will appear for all future court proceedings. The second type is what's called unsecured bail. And that is where a cash value is placed on the requirement that you appear for future court appearances, but you're not actually required to put any money down. So for example, you might have $5,000 unsecured bail. And that would mean that if you didn't show up to a future court proceeding, the next stage in your court process, you would be on the hook for $5,000, but the day that your bail is set, you're not actually required to put any cash down. The third type of bail is what's called nominal bail, and that is where you put a nominal sum of money down, for example, $1 as a condition of your bail. And when that happens, that's something that's done to allow the judge to impose additional conditions on your case. And the final type of bail is actually cash bail, monetary bail. And that would be where there's a specific amount of bail that's put on your case, say $500, $1,000, or in more serious cases, $50,000, $100,000. Now, bail is very important because if you do, for example, have cash bail and you are unable to post the bail, then you will sit in the prison until your case is resolved or you are able to make bail. And that's very important because in order to properly resolve your case, you need to be in it for the long term. You have to be able to handle the stress and the pressure of being in the criminal process. And if you're sitting in jail, you are much more likely to accept any kind of a plea deal just to get out of prison, as opposed to working for the best possible outcome that you can get. Why would you need a lawyer to work with you with respect to bail? Having a lawyer is very important because the conditions of bail are discretionary with the judge. And that means that the judge is not obligated, except in very limited circumstances, such as murder, where you're not entitled to bail. But in most other instances, the judge has the authority, the discretion to impose a range of conditions with respect to your bail. That could apply to cash bail, how much cash bail the judge is going to impose, conditions such as an inability to have contact with the victim, the ability to travel restrictions that might apply to your case, and there are other conditions as well, drug and alcohol testing, things of that nature. And what the judge will be looking at when they set bail, among other things, is they will be looking at your community contacts, how long you've been in the area, whether you have a job, whether you have any sort of long-term relationship in the area, whether you're a homeowner, whether you have extended family in the area, and whether you have a history of complying with things, or conversely, if you have a history of non-appearing for future court proceedings. And a lawyer can help you to present that information in an effective way, and also can make arguments to the judge as to why those factors should be interpreted or applied in a manner that's favorable to you. In addition, attorneys, particularly local attorneys, will have a connection with the judge and will have an understanding of what the judge is likely to do with respect to bail. And so they can prepare you, the client, beforehand as to what the judge may or may not do, and as to what kind of arguments might be effective to the judge. At any point in the criminal process, it's very important to have an attorney. But with respect to bail, it is very important because bail very often sets the tone for what's going to happen with the rest of your case. And if you get off to a bad start by having bad bail conditions or bail conditions that you can't meet, then you're much more likely to accept or negotiate a less favorable outcome just to have your case resolved, just to get off of your bail conditions, than you would if you were more at liberty, out in the community, able to assist in preparing your defense, and not under the constant strain and stress of, for example, being in prison. So for those reasons, it is highly recommended that you have a lawyer for bail, or that you contact an attorney to discuss your case and to see what likely conditions might be imposed in your case and how you can effectively advocate for yourself so that you have fair conditions that allow you to get a successful, positive outcome in your case.